Home sellers use surveillance devices for a variety of reasons, and thanks to smartphones, even today's buyers use personal devices during their home buying search. But the use of recording devices isn't without legal risk and can lead to both civil and criminal liability. So, before pressing record, watch this window to the law to learn how to navigate audio and video surveillance in real estate transactions. How you can use audio and video surveillance will depend on where the recording takes place. State law generally permits video-only surveillance without consent, except in places where a person has a reasonable expectation of privacy, such as a bathroom. That said, some states do require notice or treat recordings differently depending on whether the camera is visible. Audio recordings are trickier and are governed by both federal and state law. Typically, at least one party to a communication must consent to a recording, but some states like California, Florida, and Illinois require the consent of all parties. Keep in mind the consent must be obtained from a person present and participating in the communication. While some states have exceptions for property owners, in most states it would be inappropriate for an absent homeowner to press record and capture a conversation between a buyer and their agent without either their express consent or their implied consent through, for example, the posting of a conspicuous notice of the recording. With the ever-growing use of property surveillance, keep these best practices in mind. Address the seller's use of surveillance devices in the listing agreement. Require sellers to disclose any devices, warn of the legal risks associated with audio and video recordings, and require indemnification for any unlawful surveillance by the seller. Recommend sellers provide notice of property surveillance even when notice isn't required. And disclose any known property surveillance to other participants in the MLS. In fact, some MLSs may require disclosure upon submission of a listing. And remind sellers of their fair housing obligations. Video surveillance can reveal a lot about prospective buyers. If you suspect a seller is using video footage to violate the law, document your concerns in writing and, depending on the circumstances, consider removing yourself from the transaction. When working with buyers, inform buyers of the potential for surveillance devices during showings and of any known devices in writing. Also, counsel buyers to assume that they are being recorded at all times and to avoid talking about a buyer's interest in a property while at the property. Not only is it possible there may be undisclosed surveillance devices, but in some states like Wisconsin, homeowners aren't required to disclose surveillance devices used during private showings or open houses. And finally, advise buyers against taking pictures during a showing and to avoid posting photos online. Knowing your state law is the key to not only helping your clients navigate these issues, but to protecting you from legal liability. And remember to smile, because you just may be on camera.